you would be more interested in knowing about what has gone into the amendments and what are the points. You might be on the practical side, you might be finding difficulty in on Sarfaesi actions and might be having certain doubts and want to seek clarification. So this is an opportunity for you to raise your questions and seek the clarifications. So to begin with, what I want here to convey is that the amendments, there have been certain amendments made to the Sarfaesi Act. The acts which has gone into amendments are Sarfaesi Act, Recovery of Debts Due to Banks and Financial Institutions, that is DRT, Indian Stamp Act 1899, and the Depository Acts. So there were certain provisions in these acts which have been gone into amendment and brought under this new amendment, and this new act is called Security, Interest and Recovery of Debts, Laws and Miscellaneous Provisions Amendment Act 2016. So this is the basis, this is the genesis of these amendments. So one by one, I'll be going by some of the major amendments, because here, sorry, my request to the participants, please unmute. Please mute your microphones so that the noise is not there. Yeah, can you scroll down, Tanya? This is an act to regulate securitization and reconstruction of financial assets and enforcement of security interest, and to provide for central database of security interest created on property rights. So the basic objective is to regulate securitization and reconstruction of financial assets, which was not there. So many of the amendments have been brought in the Sarfaesi Act, and resulting into the new guidelines for the asset management, asset reconstruction company, ARCs. Then central database, the idea was to integrate the database. Registering authorities, there are, you might have find various places where the properties securities needs to be registered. So the ultimate objective is to bring all these database into under one umbrella, that is Sarfaesi. So that's the introduction. Next move. Next slide, please. So I will touching upon some major amendments. I will never be able to complete the subject because subject is so vast, and I don't want to claim myself as an expert in this subject because it's a legal issues. So being handled the matter on regulatory side, I will just try to do justice to this subject. So section 17 and 19 have been modified on December 26, 2019, which came into effect from June 24, 2020. Section 23 amended to include what has been provisions which have been amended is the removal of timeline of 30 days to file security interest with Sarfaesi. You know, all the lending institutions, banks, financial institutions, they have to upload the security interest in the Sarfaesi. This was mandatory, and the timeline was 30 days. So this 30 days timeline has been removed. Number one, to provide a right to central government to notify type of transactions which require registration with Sarfaesi. So central government by way of notification can make directions to what type of transaction is required to be registered with Sarfaesi. So watch on the central notification, central government notification. Other creditors also to file charge without right to enforcement of security. So this amendment has brought because earlier it was only for secured creditors. So now this has been expanded to other creditors also, who can file the charge with the Sarfaesi, but the enforcement of security is only limited to the secured creditors. So other creditors cannot enforce that. The right is not available to other creditors than secured creditors. Permission to person or creditor to file attachment order to get priority of such claims. So if somebody goes to the court and got an attachment order of the property, So that order to get the priority over their claims, it is needs to be uploaded or registered with the Sarfaesi. So कोई भी attachment जो है order that also requires to be uploaded on the Sarfaesi platform registry. Priority of claims. Next slide. Of secured creditors over statutory or tax dues to government. So this has been defined that even the statutory or tax dues to the government will not get priority over the secured creditor. So secured creditor has the priority over statutory and tax dues to the government. So that's a order has been maintained. Claims under IBC to be decided as per the insolvency code. So if there are anything which is, comes under suppose there is a claim or some security case and which is already under IBC. So the Sarfaesi action cannot be invoked. So you have to go under the insolvency code as per the provisions given in the insolvency codes that will be applicable on in respect of the claims or the where the insolvency case has already been registered. Section 17 of this act includes measures to be taken by the aggrieved borrower or guarantor to approach DRT within the limitation period of 45 days. So section 17 provides certain provisions, measures which can be, invoked by the aggrieved party and they can approach to the DRT, but within a 45 days time, the limitation period is given. So once they receive that demand notice or, by the lender, and they send the representation or the objections, and that is also denied by the lender, and action is initiated. So within 45 days, they can approach to DRT against the action of the secured creditor. So that opportunity has been given to the aggrieved parties. Sarfaesi action may be initiated against willful defaulters or guarantors even without notice to the borrower. So you need not to give notice to the borrower if they found to be defaulter, willful defaulter or guarantor. So the guarantor is also classified as willful defaulter in the situation when there is a resources available to him and he is not willingly meeting to that obligation which he has given to the lender as a guarantor. So the regulations is you can call them as a willful defaulter and they can be listed in the RBI list of willful default. तो willful default केस में आपको notice देने की भी जरूरत नहीं है. You can initiate the action. Next slide. There are certain amendments. So debt has been redefined. Debt to include any right, title, or interest on any intangible assets which secure the obligation to pay any unpaid portion of the purchase price of such intangible assets or an obligation incurred or credit otherwise extended to enable any borrower to acquire the intangible assets. Or so what in a short, the intangible assets, any kind of contract or any which is intangible in nature, that also has been, and that has an obligation, that kind of contract or has the obligation to pay the unpaid portion of the debt. So that is also has been included under the definition of debt by the amendments. Security interest includes any mortgage, charge, hypothecation, assignment, or any right on any tangible or intangible assets which secures obligation to pay any unpaid portion of the purchase price of tangible or intangible assets. So many of the companies, they are going for assignment also of their debts. So that is also comes under the, and if they are the institution is failing to repay our obligations, so that also comes under the kind of security interest. And assignments also required to be uploaded on Sarfaesi. So any if you are creating any charge or any by way of assignment or lease or something, that is also required to be uploaded on. So that's a mandatory. You can't initiate any Sarfaesi action unless you have registered the charge with Sarfaesi. Because the Sarfaesi uploading of charge with Sarfaesi is now taken as a public notice, public notification. which earlier the lender has to give on a paper or something before taking any action. So this central registry is now a platform which serves the need of the public notification. So that's mandatory. No action can be taken unless the security interest is created in the SAI platform. So kindly remember it in your daily process. So that's mandatory. I will come to you in detail also when I touch up the SAI topic. Next slide, please. Any document executed by bank or financial institution in favor of asset reconstruction company acquiring financial assets for the purpose of asset reconstruction or securitization shall be exempted from stamp duty. So that's a relaxation which has been given to the industry, that if any bank or financial institution, the loan becomes NPA and they want to sell that NPA to asset company, asset reconstruction company. So it is again a transfer of property. So as per the law, you have to pay the stamp duty, but this has been exempted. So that's a big relief to the industry. Section 13, the requirement of classification of secured debt as NPA shall not apply to a borrower, because what is the pre-requirement of any action you want to take is that loan should be NPA in your books, in the lender's books. So, but this definition requirement is not there in respect of the debts arising out of borrowing by way of debenture or bonds. So if there is any they not apply to borrower who has raised funds through issue of debt securities in the event of default of debenture. So this exercise, this security, the recovery would be on the part of the debenture trustee. It is not the secured creditor, but the debenture trustee, who is the registry of all these kind of bonds or the security papers. So they will enforce the security measures. So this NPA requirement is not there for this kind of claims. Next slide, please. In between also you can raise questions. I will see the reaction box if anybody has raised hands or something, so I will reply. Anyway, I'll move on. So next amendment includes where the amount of dues of the secured creditor together with all cost paid before date of publication of notice or public auction or sale. Suppose the lender, the borrower comes in with all money.
कैसा चल रहा है? ठीक.
Hi, Sanjay, can you mute yourself? You're welcome to this session.
Sorry.
Yeah, Sanjay. Yeah. So if you come to the stage of issuing public notice or sale or auction, in between, if the borrower is ready and pays you with all cost, then all the actions are the next steps would be withdrawn, and you can't move in that recovery suits. So no further step shall be taken for transfer of assets or sale of assets if the money is brought in by the borrower in between the process of in the transaction process. Suppose at the time of public notice or at the time of auction, before auction or before sale, if this kind of thing happens, then you should stop. Chief Metropolitan Magistrate or District Magistrate to issue order for position within 30 days. Generally, the time period is 30 days. But if it is not done, they can record the delay and they can reissue, modify and reissue the order within 60 days. So 60 days is the maximum time which is given under the Act for the Chief Metropolitan Magistrate or DM to come out with the issue the order for possession of the property. So because you have to take the assistance from these authorities, so you can apply, you can make a request giving all these appendixes and the format for making application to DM, system magistrate is all given in the Sarfaesi Act. So you can take down those formats and give full details of the your this thing and take an order. So this is the time period which has been provided to authorities to come out with the order. Next. Section 17 of the Act that talks about something certain reliefs which has been granted to the aggrieved party. So the aggrieved party means the borrower if they are not happy with the way you are handling or their objections and the reply to those objections, so they can approach to DRT while taking note of appeal of aggrieved. So DRT, what they will do while taking note of appeal of aggrieved party, if they finds any lapses on part of secured creditor, suppose the steps are given 1, 2, 3, 4, and you have to move in that way. If some lapses are found, you have not heard the borrower or something, so they can order for restoration of assets, or if you have taken over of management, if that action is taken, that is also is to be restored. So that's a relief which has been granted to the under section 17. And the other amendments includes integration of registration system with central registry. So as I have told in the beginning, you have to register with the revenue authorities and then registry authorities and various places, registrars. So repeated processes. So idea is that to integrate this registration. So it is not done so far, to my knowledge. If anybody knows, then it can it will be benefit to all if they can bring. So to my knowledge, it has not been integrated, but the provisions are there in the Act to integrate. So if the registration is made in any of the registering authority place, it will be deemed to have been registered with SASI. So there is a single registration that will come in place with this kind of amendment. So you have to wait. Provisions of registration of security interest extended to cover other than security creditors also. So it earlier it was available to security creditors under Sarfaesi laws. Only security creditors, secured creditors have been given, but here they can other creditors have also been covered under these provisions. Whereas enforcement of security interest is restricted to secured creditors or debenture trustee or asset reconstruction companies or any other institution notified for the purpose. So that the government notifies any institution or class of notification, a category of institutions which they can enforce the security. So they are eligible. Otherwise, as per the present provisions, present law situation, these are the institutions which are banks and FIs also they are included to enforce the security. But other than that, it is only for registering of charge. Central registry to act as a public notice. As I have said, this is a public notification. So whatever the charge you are creating and making it on the SASI, it will be deemed to be a public notice. Next slide, please. So that's some amendments which I have discussed so far. I could not discuss all the amendments because in one go. So till that point, if there are any questions, please ask the questions in between. Otherwise, we will go ahead with the rest of the topic. Any questions so far? Yeah, it's I'm giving time slot in between also. So you should not forget. Yeah, please.
Yeah, Mr. Prasad, this is Giridhar here. So
Giridhar,
if there is a delay in the DM court or the CMM court, the next option is to approach High Court.
No, need not to approach because the provisions are there and they have to come out with the order within the 60 days time.
No, but in some we are facing this challenge of inordinate delay in filing in DMM courts. So what is the relief where the financer, the banker can take if the DMM court is not acting?
First is that first of all you have to give an application to the DM or Chief Metropolitan Office, okay? And then if they wait for the queries, if they have some certain queries, some more data, some more information to, then you have to give them. And if there is a delay, you can make a request to them, because there's a provision that they have to come out with a, I don't have any redressal to that situation approaching to the High Court. At the most you can apply, because you are also free to move to DRT, because so you can move to the DRT. Yeah.
Okay.
Yeah. Okay. Any question?
Yes, there are cases. High Court has directed.
So scope and objective of the act. So basically the objective was there to speedy recovery of debt, out of court procedure, power to seize and desist, auction and the asset sale to ARCs, enforcement of security, and Sarfaesi. So now let us move to the next slide.
Okay.
Now I will touch upon role of ARCs. Now they are now called the Asset Reconstruction Company. Can you please mute Mr. PPS? Mute your microphone, please. Kindly mute yourself.
4 to 6 months time எடுத்துக்கும். அது வரலாம் RBI டைம் கொடுப்பாங்க. எல்லாம் போகாதவங்களுக்கு இந்த பொண்ணுக்கு தோசை இருக்கு.
Yeah, role of ARCs basically is acquire financial assets by issue of security receipts or debenture bonds, or by agreement realize the same and redeem the security interest subscribed by QBs. This is the qualified buyers. Take measures for proper management, sale, debt restructuring, settlement, or take position subject to RBI guidelines. So these are the certain functions I just touched upon. Enforce security interest without intervention of the court. They can do that. Act as an agent of bankers' FIs for recovery. Move to next slide, please. And act as manager of secured assets appointed by the lender, or act as a receiver appointed by the court. So the other broad functions which has been given to the ARCs to perform. So next slide. Now the question is, what kind of loans are eligible for where you can initiate the Sarfaesi action? So you know it was earlier banks. This initiation of Sarfaesi was extended to banks and financial institutions. Then NBFCs were covered. Housing finance companies were not covered. Then later on, by a new notification of the government, I think of February 21, the HFCs has also been included in the Sarfaesi. So you are also being, the HFCs is also included with the 20 crores or other companies which are approved or got the registration by the NHB. All the approved HFCs, they are being brought under the Sarfaesi platform, and they are being now regarded recognized as a financial institution in terms of the Sarfaesi Act. So what kind of loans are classified as NPA? First of all, the loan should be NPA in the books of the secured creditors. The second, NBFC allowed Sarfaesi action for minimum size of loan of 20 lakhs. So 20 lakhs and above is the minimum size of the loan which you can take Sarfaesi action in any claims on respect of loans of 20 lakhs and more. You can initiate the Sarfaesi action, not below that. The banks and FIs are eligible for minimum size of loan of rupees 1 lakh and above. But in case of NBFCs and HFCs, it is 20 lakhs. The second condition which falls into the definition of eligibility is that where the principal and interest in total outstanding loan is not below 20%, should not be below 20%. If it is below 20% of the total outstanding, then you can't take that particular loan under Sarfaesi. Where the principal and interest is below 20% of the total outstanding. Agri land is exempted. Residential houses also cannot be attached until the same is covered by the mortgage. So if somebody has brought that residential house under mortgage, then you can initiate. Otherwise, you can't attach any residential house. Money or security issued under Indian Contract Act or Sale of Goods Act or any conditional sale, hire purchase or lease or any other contract where no security interest has been created, they are exempted from the Sarfaesi action. So you can't take the Sarfaesi action on any other kind of security, money or security issued, where no security interest has been created. Applicable to pledged security of defaulting borrowers. So if somebody has pledged their security, so that also you can initiate the action that is also covered under the Sarfaesi. So next slide, please. Any question on loan eligibility or the role of ARCs? If somebody wants to have any no? So here I will just gives you the flow chart of recovery of loans under Sarfaesi. So option under Sarfaesi is enforcement without intervention of court and auction sale of underlying asset. Or one option is this side, when you can directly, because you are empowered as a secured creditor, you are empowered to take those action. Or you can sell your NPA portfolio to ARCs and get the cash flows, ready cash flows. And then ARCs will do their rest of the job. So they will sale of assets, management of business, or by selling a part or whole of the business. So because they are authorized to do all those actions. So that's the easy way of doing it. And you sell your portfolio, NPA portfolios, which you think is non-recoverable or difficult to recover, and get the ready cash flows from the ARCs. Next slide. The other flow for, because section 13 is very powerful. It talks about all the procedures to be followed and what stage, what's the time period and all those. So that should be read very properly. This is the section which covers the banks and FIs, classifies accounts as NPA to begin with. Yes. Section 13.2 is which talks about the issue of demand notice. And if you issue a demand notice, it should be, the 60 days period is given to repay the loan in full and final. So 13.2. So how to issue a demand note? What are the information to be brought in the demand note? That is also very important. You have to give the complete details of your loan. Then against the demand note, once you issue a demand notice, there is an opportunity given to the borrower who can represent, or they can send objection to your demand. So there could be some technical objection also. Suppose certain details are not conforming or something. So once you receive this representation or objection from the borrower, you have to immediately attend to it within a 15 days time. Either you accept it, and once you find that okay, there is a genuine representation or objection and which you can accept it, so you can reissue the demand notice. If you are not accepting this, then you have to reject and give the reasons for rejection within 15 days time. So time period is very important. The bank must suitably educate or rely upon such representation within 15 days time. So that is covers under section 13.3a. So you have to be careful. Issue notice for taking possession of secured assets. So the next step is once you have rejected the representation or the objection of the borrower, then you issue notice for taking possession of secured assets. So then that comes under section 13.4. Next slide, please. I'm not able to see this application before Chief Metropolitan or District Magistrate for actual position. So one is 13.4 is a symbolic position. Then you are going towards the actual position. So you are approaching to the civil Chief Metropolitan or District Magistrate. This covers under section 14.4. Then you comply with the order of the magistrate, section 14.2. Notice of position to be sent to the borrower, and the same is to be affixed to the property. So that is rule 8.1 of security recovery rules, security interest recovery rules. So that talks about that you have to give a notice to the borrower of position and affix this to property. That is also within 30 days. You have to wait for 30 days and then only. And the aforesaid notice to be published in 2 leading newspapers, one in vernacular language within 7 days. So you have to come out with the 2 publication. One is leading newspaper and one is vernacular language, which is locally read, circulated by most, is a larger circulation in the area. Next slide. Then you have to go for valuation of property by approved valuer before affecting the sale. So you have to take the approved valuer and get the property valued and fix the reserve price, and then a 30 days notice of sale to be served on the borrower under rule 8.6. And then obtaining quotations, inviting tenders, holding public auction, or signing private agreements for the sale of the property. So either of these 2, e-auction is also applicable. So you can go for e-auction and either or you can ask for obtain quotations, tenders, or a public auction also, or private agreement also. So whatever be that, and you can go for sale of property, and then sale is concluded proviso to rule 8.6. So these are the steps which you need to follow. I have not been able to describe in full, but I have just brought before you the flow. When you are going for practice or you going for any action on the ground, you should be very well equipped and well thorough in the steps which you are going to take. Yeah. So far, any questions? Kindly share the PPT post this call for your internal. Yes, the PPT Girdhar would be shared with all of you by the company. Next slide, please. So I am bringing some topics for discussion, open discussions, because instead of making the session boring and one-way communication, I am putting up some subjects which may attract some discussions. One is the authorized officer, because as you know, the company, any of the bank, or they have to appoint an authorized officer to handle this kind of actions. So an officer not less than a chief manager rank of PSP or equivalent, so should be there, as specified by board of directors or board of trustee. So who will appoint the authorized officer? It is the board of directors or the board of trustee in the case of debenture trustee. And they will appoint, and they should be well versed on the subject and should be equivalent to the chief manager of the public sector banks, because they're going to have a very important role to play, exercising powers of superintendence, direction, and control and rights of the secured creditors. So then they will be issuing the demand notice, the notice in writing to discharge in full the liabilities to the secured creditors within 60 days from the date of notice, failing which the secured creditor shall be entitled to exercise all or any of the rights under section 13.4. So these are the functions which is falling under the role of the authorized officer. So they should be well versed on the various provisions and the consequences of those legal provisions in the Act. Next slide. Service of demand notice can be made by hand delivery, by registered post, by courier, by mail, fax, etc. at a registered office or branch office or residence to the borrower, including co-borrower, agent or directors. If there is a firm a body incorporated, then it would be directors also. So you can serve the notice to the agent of the business unit. You can serve. Even co-borrower also should be given notice, demand notice. And the preference should be by mail also. Electronic mode is preferred vis-a-vis with other modes of transmission of the demand notice. Yeah. Any representation or objection received to be replied or revised demand notice to be issued within 15 days. If the amount is in demand is not paid within 60 days, then the secured creditor, they can take one or more measures under section 13(4) by taking position of movable, immovable or assets under pledge. Because if there are any movable assets which is also coming under the security, you can take the position of those immediately, or under assets which are under pledge also can take in position. And next slide. Assets under possession should be insured first and kept in custody of authorized officer or the person who is appointed for that purpose till they are sold. So you have to take the security and custody of these assets as if they are owned by you. So and that should be insured also to save from any loss or any kind of this thing. A notice to a debtor of the borrower to pay unpaid, because that particular company or the borrower might be having some liabilities and which is to be paid off by the debtor. So you can issue, in case this situation comes when you take hold of this and issue a demand notice, you can send notice to that particular person who is to pay to that company. Instead of paying to that company, they will make payment to you, secured as a secured creditor of this. So there's notice also you can issue, notice to debtor of the borrower to pay unpaid liabilities to authorized officer of the secured creditor. And whatever the money is paid by that, who has a liability to the company now paying to you, it should be taken towards the, it should be kept in a separate account, and it should be taken towards the setting off of your claims. So that's also the functions under the authorized officer. So any movable assets are which are undergoing decay or where cost of upkeep is more than the value of the property, you can immediately dispose of. You need not to wait and keep the assets and wait for any further action or decision. You can immediately, movable assets can be sold off. This is permitted in the Act. And where they are decaying, some or their value, the undermining value, they are deteriorating their value, or the cost of upkeep is more than the value of the property, you can sell it off. Borrower shall be intimated by notice, including electronic mode, by enclosing. And whenever you take hold of this movable assets, you have to have a panchnama. Panchnama with a list of the objects which you have got, and make inventory of it, and intimate to the borrower also by electronic mode that this is the movable assets which you have got in our custody. So quoting all those, you have to quote the sections of the Act also, because it should be legally drafted. It is not a common, this thing. It should be legally drafted and conveyed to the, intimated to the borrower by electronic mode, that is mail. Yeah. Next slide, please. In the case of shares in the body corporate, so notice to the borrower to transfer the same to the secured creditor, and also notice to corporate registrar not to allow transfer of shares to other than secured creditor. If suppose you have a kind of security in the form of shares, and that is also comes under your securing the claims. So if you have investment in the body corporate, so and the loan becomes NPA or something. So in that case, you can issue first of all issue a notice to the borrower that the shares should be transferred in your name, or you can issue a notice to the corporate registrar that they will not allow any transfer of shares to any other person other than secured creditor. So that is also an availability with the opportunity which is given to the secured creditor. Issue of certificate of sale of movable assets as per when the sale is over of movable assets, you have to issue a certificate of sale. That is a final certificate as per Appendix 3 of the provisions of the Act. So next slide, please. Any questions so far? No. This is the subject which I am not under securitization or the Sarfaesi, but it is generally asked for reposition of security, how to go about it, and all those. What are the regulatory view on this reposition of security? Because so what we here a reposition clause should be built in the loan agreement. You can't go for reposition unless they have been brought in the loan agreement or contract, which should include and that agreement, the provision should include first notice period before taking reposition, circumstances under which the notice period can be waived, procedure for taking reposition of security, provision regarding final chance to be given to borrower for repayment of loan before sale or auction. Suppose you are going for sale and there is a reposition and customer wants to repay your loan. So that provision also should be given under the agreement. The provisions regarding final chance to be given to borrower. So opportunity should be given to the borrower. The procedure for giving reposition to borrower. What would be the procedure for giving reposition? That also should be narrated in the loan agreement. Procedure for sale, auction of property, how you are going to dispose of the property or sale, taking Sarfaesi action or DRT or whatever. So that also should be elaborated in the loan agreement. And this in the beginning of this, at the time of sanction, the copy of such terms and conditions contained in the loan agreement, along with all enclosures, must be furnished to the borrower at the time of sanction or disbursement of loan. So that's the regulatory view, which I wanted to share with you regarding the reposition, because the questions were asked how to go about reposition. And so these are the things which should come before in your loan agreement, covering all those provisions. Then you can go for reposition. Next slide. Here, this slide is talking about certain provisions which has been made in the Sarfaesi. So objective is to have a centralized database. You have to register your financial security, interest in security in the Sarfaesi platform. That is made mandatory. And any modifications or any satisfaction of charge is also required to be registered with the Sarfaesi. But now it has assumed a very important place that without registering, you can't initiate any Sarfaesi action. So, so you have to be careful. Please take note of this. Registration of interest, including attachment orders, will serve as a public notice. This I have told you. Any subsequent security interest on the property will be subordinate to a pre-registered interest. So if you are not registering, then any subsequent interest you are registering will be taken on it will not be given any priority. No time limit is specified for registration of security interest with Sarfaesi. So earlier the time limit was 30 days and there was a penalty and all those. So all those things have been removed because now this has been made mandatory. So you can't escape this kind of requirement. Security interest shall mean security interest in immovable property by mortgage, other than mortgage by deposit of title deeds. Security interest created by way of hypothecation of plant and machinery, stocks, debts, including book debts or receivables, whether existing or future. So that is also to be registered. Security interest in intangible assets, being know-how, patent, copyright, trademark, license, franchisee, or any other business or commercial right of similar nature, that if you have any kind of this security interest, that is also to be covered under registration. Security interest in any under construction, residential or commercial or part thereof of any agreement other than mortgage is also to be registered. So this is the basic changes which has been brought in the SASI. And as I have told in the beginning, the entire idea was to integrate and create a central database. So there will be requirement at registering of charge only at one place, and it will be deemed to have been made a public notice or registering with the SASI. So I think I have come to the end of the session. Please, next slide. Yeah, so that comes to the end of a session on this. If you have any questions, clarifications, now the session is open for the discussion.
Thank you, sir. The floor is open for questions now. So if any of you have questions, you please feel free to raise them. Mr. AP Saxena.
Yeah. Yeah, please ask the question. You can write it on chat box also. The chat box is also available to you. Any questions? Yeah, Rohit.
Yeah, hi. Good afternoon.
Yeah.
Just wanted to seek some.
Can you introduce, for the benefit of others, can you introduce yourself, which company you are from?
Sir, I am from Sandbank Home Finance Limited. I am heading the recovery department over here.
Oh, very fine. Sandbank, yeah.
Yeah. Sir, just a small clarification. In the case of deceased borrower or co-borrower, when we are getting the things, when we have issued the notice, after that, when we are proceeding for 13-4 or say in meanwhile, in between that period, someone comes up from the borrower's family or co-borrower's family, they come up and say that the borrower or co-borrower has deceased. And we have already,
both have deceased.
anyone or any of the cases.
Okay.
So we need to reinitiate Sarfaesi proceedings for that.
First of all, you know, Sarfaesi is there. It's a बहुत बड़ा अस्त्र है ये. लेकिन जो आपके normal course of actions हैं, recovery के हैं, procedures हैं, that should be pursued also. First of all, in case of deceased of a borrower, yes, co-borrower is bearing the same kind of liability and have to clear off the loan if there is a co-borrower in your loan. And in case of deceased borrower, whatever the insurance or something will also comes to your rescue, because, you know, idea of these actions is not to depurchase anyone from the property.
Yeah.
Idea is to streamline the recovery process, remove the legal hurdles, delays, and all those things. Because these provisions were otherwise, you know, for the benefit of all, I'm just telling, these provisions are not new. they are available at various other, plethora of laws and scattered over. So what they have done, they have assimilated in a one common act provisions, so that it could be brought in and action could be taken speedily. And the idea is to enforce the security and the recovery. So to your question, if you have issued a notice, suppose under Sarfaesi to the borrower and he has died, then you have to reissue the demand notice. You have to take the fact of his death in your account and
That
reissue
notice will be reissued. Say, for example, the legal hire details are not being shared. Many things are going around that they have been stubborn, not providing details of legal hires even after we have sent them a notice.
No, the co-borrower is there, na?
The co-borrower is there. Co-borrower is there.
So you can issue in his name, and if there is a guarantor also, you can issue in his name.
No, there is no need of seeking legal hires of borrower or co-borrower.
No, because on your record, the co-borrower is also a standing equal liability.
Yeah.
So when he has signed your agreement, because it is under your agreement, he has signed. So he is standing up to the liability in case of death. So first, you take the action from insurance company or something, recover your dues as much as possible. And then you have initiated and you have already issued a demand notice that a person has died. You can issue second notice to the name of the co-borrower.
Actually, what has happened during the course of going forward into 13.4 or section 14 also, under section 14, some applications have been rejected due to this reason. Quoting this only.
What is the size of the loan? Loan size?
Maybe ranging from 15 to 75 lakhs.
Sir, if there is no co-borrower or guarantor, then what? If there is no co-borrower or guarantor, then what?
And the person has died, single borrower.
Yes.
Then you have to go for legal hire, who is the next antecedent, the next person.
So we normally what we do is, sir, we send a notice asking the family to share the legal heirs of the dead person. But if they don't respond, then what is your other option?
Then you paste this thing, paste this notice. If it is not serving, you are not difficulty in serving to the person, then you can paste it and go for further steps in the action.
Actually, what we have been practicing, we will, if they are not providing the legal hire details, say for example, sir, I said 7 days notice we will give them to provide the details of legal hires, then we will issue another notice saying all unknown legal hires of the deceased.
Okay.
Because now when we have asked the details they are not sharing, then we will go by that and proceed further. Or in all other further proceedings, we will mention the same.
I think you have to take some legal action, some legal help in this matter. Okay.
Because Act is silent on that. No, Act is for these things. And
you can file a DRT also, civil suit.
It is just simple things are being said. A notice cannot be sent or delivered to a deceased borrower, co-borrower, whomsoever it is.
Yeah, surely, definitely. Yeah.
And on those lines, applications filed at DM court, be it DM court, being challenged and kicked out.
Okay. I ask our legal expert is also available. Can I ask Sumesh to answer this?
Sure, sir. He will just.
Can just address it to Sumesh if he can address it to this question, because it's a practical situation.
Sure.
On the ground.
Yeah.
If you have a trail ticket, you can go.
Hello.
Yes, sir. Mr. Sumesh is here for the question.
Yeah.
If you repeat the question for him, please.
Rohit, can you repeat your question? And now
yes,
our legal expert is there.
Hi everyone, this is Sumesh Chavan, Lex Favios.
Hi Sumesh, I am Rohit from Sandbank Home Finance Limited. I just had a small query That is a
Yeah.
practical problem we have been facing during the course of Sarfaesi, that even if we have issued a 13-2 notice to borrowers, after that, maybe initiation of Sarfaesi, we came to know that a borrower or co-borrower, whomsoever, at least even one of both of them have passed away, is deceased. Then we have to move further with Sarfaesi action under section 13.4.
Right.
And we have to send a recall notice again by getting the legal hire details, or even if the legal hire details are not being given by co-borrower, then how we can proceed with that particular notice, or how we can proceed ahead otherwise.
See, because if practically what works is if, once you have issued 13-2 notice and you have come to know that one of the legal heirs or one of the co-borrowers has deceased, so then you need to recall the notice and send a fresh notice to his legal heirs. So basically the notice has to be recalled and a fresh notice has to be issued to the legal heirs of one of the borrowers.
If they are not sharing the legal hire details, are being not shared by them, or anyway we are not getting them, then in that case what should be done?
So then the only way is to go file an application with the DRT. Because 13-2 notice, if you because practically if you send a 13-2 notice to a person who is no longer alive, that notice is not per se valid.
Yes.
DRT.
So the only option will be to approach the DRT and file an application to send them a notice asking them to complete
DRT will file an OA, we will go for original application and proceed with that. That means Sarfaesi will end if a borrower is deceased and co-borrowers are
but
not.
why will it be so difficult? But practically, why will it be so difficult for you to get the details of the legal heirs?
In some cases, they are very stubborn, not sharing the details. In some, they will give complete details.
So you need to, again, that's more of a practical issue where you need to just send someone to a borrower's home and check who are the legal heirs. I don't think that should be very difficult.
I think the best approach is to file an application with DRT, because even if you can't overstep, you can't initiate further steps action in Sarfaesi.
Because there are various citations given by high courts also in this regard, that SBI and other banks are also sending notices which we have came across, mentioning all unknown legal hires if they are not getting details of legal hires. And under section 17 also, if DRT is being approached for that, they have passed the regulations. But DRT orders cannot be taken as citations. Some high courts have given the orders that all legal hires ka diya hua hai proof and all those things, and that has been justified by the authorized officer, then it is quite good. But it depends. It depends.
It depends, because see, unless you have a legal heir, it will be very difficult to, for you to go and actually 13-4 and steal the premises, unless you are aware who is a person who is responsible.
Okay, you have to take the local help or something.
Maybe we can discuss this on a separate note, actually, Mr. Rohit.
Yeah. Rohit, you can mail your questions to this.
Sure. I'll do it.
Yeah, and we will try to bring some solutions to this. Okay.
Okay, sure.
Yeah. Any other question? Any point you want to discuss, seek clarification?
Yes, sir. So we have some questions in the chat box, which I'd like to bring to you.
Yeah.
So we have a question. Can Sarfaesi proceedings be challenged in a writ?
Tanya, if there is no more questions, then we can wrap up.
Hello. So am I audible?
Yeah.
So am I audible?
Yeah.
Yeah, I'm saying that we have some questions in the chat box which I'd like to bring to you. So
what are those?
Yeah. Yeah, the first question is that can Sarfaesi proceedings be challenged in a writ?
Definitely, yes, because that is why DRT is there. If any of the procedures, if there are lapses in following the procedures, and it is brought to the in an application to the DRT, and they consider it that yes, there were certain lapses made by secured creditor in the then it can be challenged in the rate. Yeah.
The next question that we have is that is it possible to move a legal action for below 20 lakh cases?
20 lakh cases, yes, you can, not Sarfaesi action, because Sarfaesi action has been, minimum size of the loan outstanding, whatever the claim size is 20 lakhs. But if it is falling below 20 lakhs, you can take the other course, legal course, civil suits or the DRT. You can always go for that, but not under Sarfaesi. For the banks and FIs, they have been brought to 1 lakh, but not for the NBFCs. So that's there. Next is, can we proceed for auction of property after taking the symbolic position before going the proceedings under section 14? So yes, you can go for auction after taking symbolic position and taking the help of the local authorities. You can go for physical possession of the property and sale of the property, but you have to go step by step, follow the procedures which has been stated over in the various sections 13.4 and further. You have to give due, idea is to give opportunity to the borrower till the last stage before you go for actual sale. If that opportunity should be made available and the objections or the representation of the borrower should be heard properly and should be replied in time. So you can go for a physical position. Yes.
Amren, the small question related to the same thing.
Yeah, Rohit, yeah.
Once we have taken the possession of property through section 14, sometimes what happens ki borrowers are very sometimes they will not vacate the property. Some goods are left behind and we take the possession because authorities are in very hurry ki jaldi possession lena and we have to finish the proceedings and all. So the goods lying with us which are not lien marked or which are not mortgaged with us or in any type of security with us, and we have to warehouse them for long period of time.
No, if it is not mortgaged,
yeah,
those properties are not under consideration of sale or auction. You can take the position of the property which has been mortgaged in favor of the secured creditor, lender. So if somebody is staying in a house, you can't get a position and sell it.
No, at times goods are kept there itself. They will say we are
No,
out of the property.
no,
You take
Rohit,
the
if the property say, if I have mortgaged certain property and you are going as per the procedure, and then you take a local help of the authorities, and then they will help you to get this vacated and get the position and go for auction and sale.
we get the vacant possession only. At times, some borrowers will leave this.
So that is left to the authorities. Police action is there. Police action is they can break open and they can break open.
Inventory. In that inventory, everything is mentioned. As per videography, the stock lying over
because,
there into possession.
Provided you have issued notice of sale also, you have issued notice of auction to the borrower also, and white publication have issued, pasted this on the property and they made it in the public newspaper also. So all these processes have been followed, and then the authorities will go by that, and they will make it vacant position available to you. So that if there is a police action is required, that can also come to your rescue.
So sale notice will come after we will take the possession. Once we have taken the possession, then only I'll issue a sale notice and go for auction.
Right.
At that point of time, when some goods are there, then we face trouble in selling the properties. We will send notice to the borrower again. ये आपका लगे सामान पड़ा है वहाँ पे, you vacate it, and for that, if he is not coming, then we will warehouse it. That is also an expense which is going on.
right.
What procedure we have to follow for that goods which are not mortgaged with us, and we have to sell it off, we have to auction them, because the
So,
mention in the act is that we have to warehouse the goods which are not mortgaged with us, and we have to keep under insurance and everything we have to do.
I'm not clear about this thing. You can again mail it. We'll have
Yeah,
see.
we'll mail it.
Yeah,
We'll see.
yeah. Rohit. Any other question? Yes, Tanya.
Anyone has any questions, please feel free to raise them.
So please make the PPT available to the participants of this session.
Surely, and lastly, I would really like to thank Mr. A.P. Saxena for enlightening all of us with his in-depth knowledge and providing us with such a deep insight on the various facets of Sarfaesi Act. So thank you very much, sir. And I would really like to thank all of you for being with us here today.
My approach has been on the theory part, but the ground realities are totally different from what is given in the theory. So you might be experiencing some difficult challenges also. So that is also becoming an example to rework and reconsider and make this suitable. So making amendments to this. So thank you everybody for their participation and asking questions and making the sessions good for everyone. Yeah. Thank you.
Thank you, sir.
So we can wrap up.
Thank you, everyone. Thank you so much.
Okay. Thank you.